Hi everyone, this is Conn Maciel and I'm joined with my partner, Mark Trapp. We are from the law firm of Conn Maciel Carey in the Labor and Employment Practice Group. Thanks for joining us today for our webinar, NLRB Update, Senate Confirmations, Union Organizing and Election Rules. So we appreciate everyone's participation today and look forward to the webinar. And with that, we'll go ahead and get started. So we're going to cover today really the National Labor Relations Board. I'm going to start the first half of the program talking a little bit about the board, the makeup of the board, the the issues that's facing, particularly as it relates to sort of the newer members, what we might see if we see any changes in the administration, and in particular some union organizing activity that's happening with COVID and some changes to the election rules. And then I'm going to hand it over to Mark, who's going to cover the latter half of the webinar on some really recent decisions that the board has been making and how that would impact you and your workplaces. So for just at a very high level overview of the board, the board is made up of 5 members. It sits in Washington, D.C., and primarily acts as, a quasi-judicial body in deciding cases that are formed on the basis of lower administrative proceedings at regions around the country. And so those board members, they're appointed by the president to 5-year terms with Senate consent. And each member's term should expire on different years. So you've got a rolling vacancy. As you can see right now, we only have 4 members of the 5-member board. And that's a good thing because just a couple months ago, in the end of July, the Senate reconfirmed 2 members that allowed the board to have a majority. Prior to that time, there were just 2 members of the board, Chairman John Ring and Bill Emanuel. And without a quorum of at least 3 members of the board is unable to rule and act on any of its cases, and it essentially comes to a standstill. And so after really much lobbying from the business community and others, the Senate reconfirmed Lauren McFerrin and Marvin Kaplan to the board as a package deal, 1 Democrat and 1 Republican, which restores the majority of a Republican majority to the board, which is often the case during the, whatever administration is in office, that generally is the party that then will control the board. Just giving you a little bit of background, these 4 members have been on the board for a while. Chairman John Ring was appointed back in 2018, and he will remain on the board until the end of the year of 2022. He comes from a large management side law firm, Morgan & Lewis in DC, and so has some pretty good management side, collective bargaining, union negotiations, elections, union organizing, a background. Marvin Kaplan is the gentleman on the far right. He was also nominated right after, really after the administration started to take office in 2017. His term expired. It was a shorter term, but he, as I said, was just reconfirmed at the end of July. So he will have a term through the end of 2025. His background really comes from government service. He served a number of years for the OSHRC, the OSHA Safety Review Commission, and prior to that worked on the Hill for the House Commission on Oversight. So he has a really good regulatory background, really knowledgeable about the way that administrative procedures and administrative regulations pass through the agency and through the board. Bill Emanuel, he has been on the board really from the beginning as well with John Ring. He was appointed in around 2018. And he comes from a large management side labor and employment firm, Littler Mendelson. And then finally is Lauren McFerrin, who is the sole Democrat on the board. She had served on the board from 2014 to 2019, and she was reconfirmed with Marvin Kaplan, so her term will go through 2024. She had, prior to the board service, been on the Hill at for the Senate Help Committee, being the chief labor counsel, and prior to that worked for a very well-known labor plaintiffs firm here in Washington, Bredhoff Kaiser. So these 4 individuals, have been on the board for a while. They know each other well. They have a pretty good working relationship. and their terms will continue through the next administration with one vacancy. What will happen, and before I do that, Mark will talk about this as well. Really, over the last 4 years or so, 3 to 4 years, the majority of the board, being Republican controlled, has really shifted the decision making and their rules and procedures much more back to a very business friendly approach. They've taken time to try to restore some of the common sense decisions based on confidentiality in the workplace, based on handbook rules, some other, important issues that have been happening during the Obama board. They also, I'll talk about this in a few minutes, they have tried to amend the election rules that make it a little bit easier for employers to respond to union petitions that the previous board had put into place. And so what happens a lot is, depending on the administration, you will see the board shift and swing in their decision making based on sort of the political environment in the area. And I don't think that's going to change anytime soon. If we see a change of the administration in next year, we know that Joe Biden will be very, very union friendly for purposes of the labor board. Earlier this month, he gave a speech to the AFL-CIO in which he said, "I'm going to be the strongest labor president you've ever seen." And he told those business leaders that he will, in union election organizing campaigns, if a business leader, if an executive interferes with the union organizing, right now that's an unfair labor practice charge, and a company can be fined for an unfair labor practice if they do something wrong during an organizing campaign. And what Joe Biden has said is that he will now fine those executives and business leaders with personal liability if they are accused of union organizing violations through an unfair labor practice. So that's a really important potential change that we could see from the board. He also indicated in his speech that he's urging a ban on right to work states. Some of you may know, if you are in a right to work state, then you do not have to require your employees to be part of a union if a union is part of the workplace. It's not a condition of employment, whereas non-right to work states, if a union is formed and employees are part of the bargaining unit, then they have to be part of the unit and pay dues, et cetera. But that's not the case in right to work states. So he is urging a ban on those, which would also be a little bit of a damage to business leaders. So one thing I want to cover that I think is interesting is what's been happening with the board, particularly on elections, since COVID-19. The board was shut down for about a month, 3 to 4 weeks in March. They reopened on April 6th, 2020. And really since then, they've held 18 elections on average per week, which is down from the number of elections they held before March 2020. And that was 21 elections per week. And we're seeing that to be similar, that really from this year in 2020, since January, we're starting to see case intakes dropping to about 14,000 compared to that 17,000 during the same time period last year. So there has been decreased activity from the board, and I don't think that that's unusual nor uncommon. I think that's a continued trend over the last several years, where union interest and union organizing has been on the decline in the private sector. We do see that, however, the median time between a petition and election is about 23 days. That's the result really of the new election rules. That was the union's goals to try and shorten that time period for elections between petition and election. If it's contested, we're still seeing on average about 42 days if the union it's contested and there is ultimately goes to an election. And as I mentioned, part of this is due to sort of new election rules. So there were election rules that had taken effect over the Obama board that really was met with strong resistance from the business community. And when the new board majority came on, they spent several years looking at those rules. They asked for public comment to see how they should change those rules, if at all. They ultimately decided some of the rules did need to be changed, and those were published back in December of 2019. They were supposed to take effect in April of this year, but the labor unions brought litigation in district court, and the district court ultimately held at the, I think it was the end of May, that there were some provisions, a majority of the provisions were left intact, but there were a few provisions that were vacated by the court. The board disagreed, of course, with that ruling, but went ahead and implemented the majority of the rule that left that intact. And really what that deals with is primarily timing issues. So what it does is the new rule allows parties additional to comply with the various pre-election requirements that had been instituted back in 2015. So for example, how many days you need to schedule the hearing, how much time a company has to post the notice of election in their workplace, how much time you have to serve a statement of position on the board and the union about whether the unit is appropriate. A lot of these are a lot of very procedural requirements, but they're important. And I think what happens and what the business community was finding is once an election petition came on their desk, the new rules that had been implemented during the Obama board just left them really flat-footed. There was, it was like 24, 48 hours. A lot of things had to be done within a very short amount of time. Otherwise, companies lost their rights under that, or lost legal arguments that they could have presented to the board about the proper composition of the unit. So it's really important that these new revised rules gives a little bit more timing and a little bit more leeway for employers to kind of respond to the union organizing activity. It also reinstated this procedure to allow more opportunity for litigation and the resolution of the unit scope and voter eligibility prior to an election. For example, is someone a supervisor or not a supervisor, and whether they should or should not vote in the election. There was questions about whether that issue should be held until after the election to determine whether that individual's vote would even be determinative. But one of the challenges that we face as management side lawyers in defending against union elections is if you have an employee who arguably is a supervisor who is allowed to vote and allowed to participate in the union election process, and then later that person is deemed to be a supervisor, it calls into question whether that supervisor was engaging in an arguably unfair labor practice charges, coercion or surveillance, and it just created a huge problem not being able to litigate that issue before election. And so the new rule does allow us to do that. As I said, those old rules had been in effect since 2015, and it really forced employers to be ready before any organizing could occur to respond effectively. That's still something that I advocate and something I'll talk about in a few minutes, the importance of always being ready for a campaign 365 days a year, because oftentimes you're not going to know that union activity was occurring, and that's definitely the case now in a post-COVID world. But we also felt, the 2015 election rules limited the ability of open communication about the choice to vote for or against union representation. And so having a little bit more time and having the ability to litigate some of those issues pre-election allows that communication a little bit more freer to be communicated to your employees before that decision is made in an election. So I want to spend a couple minutes talking about some recent union organizing due to COVID safety concerns. We have seen, and I think this is probably no surprise to everybody on the call, that there has been an onset of worker activism in the last 6 months. Not only, and I would say primarily, over workplace safety concerns, but we're seeing the workplace activism through protests on racial concerns and other issues, still seeing concerns over minimum wage, a variety of different things. And that worker activism has really been forced to take a new role since COVID-19, with everybody working from home or not having large meetings, not traveling, and union organizing also has changed as a result of that. So what in traditional industries where we had essential workers like healthcare, like the grocery industry, retail, airlines, and other manufacturing, those plants and those workplaces remained open since March. They didn't have a lot of telework options or possibilities. And so we did see really renewed focus by workers and unions trying to get into those industries if they weren't already organized for purposes of organization. And the topic, and as no surprise again, is workplace safety. So is this workplace, is the employer doing enough to make sure that its employees are safe? Are they providing the right protective equipment? Are they providing gloves and masks? In a grocery store, is there plexiglass shields being put up? Now I think we're starting to see that happening, as a matter of course in many industries, but at the beginning in March and April, when so many employers were really challenged by all the new regulations and all the things that they needed to be doing, the unions really took advantage of that opportunity. And so these are really the hot button issues that we're starting to hear from unions as well. And that's true too in the way that they organize, right? So now traditionally unions were organizing by going to people's homes and meeting people in their living rooms, or having a pizza party at a local restaurant, or reserving a hotel conference room and getting employees to meet and talk about organizing. Now what we're seeing is the Zoom union campaign. Unions are taking advantage of the opportunity to chat with people in the privacy of their own homes through Zoom and other platforms. And that has really allowed some employees to feel more comfortable about talking about unionization or hearing about the union message. They're not afraid that their manager or supervisor is going to walk into the break room if they're talking with their coworkers about it. So it's been very interesting to see this shift from the old school kind of art form of face-to-face engagement, one-on-one meetings, to more of an online version. We've seen union campaigns successful among teachers and nurses, medical technicians, where they've been organized through online methodology. Hospitality workers that that industry has been hit terribly with layoffs, across the country. And we're hearing that Unite Here is taking advantage of conference calls in multi-state jurisdictions in order to gather people's ideas and share tactics about how they can come back and what they need to be doing when they do return to work, with a renewed focus on workplace safety. So the worker activism, I think, issue has been really interesting over the last several months, and that hasn't also translated into contract negotiations. So even unions that are already in place, if they've got a contract that are expiring this year, we're starting to see a lot more contract negotiations also happening via Zoom or other online platforms. It's not ideal because oftentimes you're usually sitting in a conference room, and then you can break out into different breakout rooms and have your caucus. The union can caucus with its members, and the management can caucus with its members. Zoom has some of those features. It's not perfect, but we are starting to see a lot more of that. And so it's people are adapting to the way that they're organizing workers, and they're also starting to see it through litigation. We've seen one company, Smithfield Foods in Missouri, they were sued by an employee, particularly for these reasons of lack of protective equipment, lack of breaks, and the news articles that were discussed mentioned that it was members of a union that were used to promote and raise these safety risks. The lawsuit has been dismissed by federal court because, as most federal courts should know, OSHA is really the one that is the agency that investigates workplace safety issues, and there's no private right of action by an employee for an OSHA general duty clause or any other OSHA issue. OSHA ultimately fined Smithfield Foods for COVID-19 related deaths that was reported earlier this week. But just to be aware that these issues can come up a variety of different ways, and we've talked about this in the way unions organize, that it's death by 1,000 cuts, and it can, whether it comes from an OSHA complaint, whether it comes from an employee lawsuit, whether it comes from news media and editorials, it can come out a variety of ways, and they will use right now workplace safety as their main target of why employees need to have union representation. So with that, this is, what I mentioned earlier, regardless of whether we're under the, the old election rules or the new election rules, it's our advice that you should always have a strategy before any union petition is filed in order to facilitate really an immediate and effective response to union organizing, especially now that you may not know what's happening on a remote workplace Zoom conference call, and it might be even more surprising if you get a union election petition than before. So the first thing we advise is that you have a high-level management team to handle your election petitions and campaigns. That should be the CFO, that should be the HR, it should be someone who knows benefits and payroll. It could be security, so they know, where things are to respond and who to have in the building, where your perimeter is. Important to have this multi-level management team to be able to respond if something comes in. Oftentimes a union petition can be faxed, and sometimes it's sitting, on a fax machine or in an email box for a while before you may see it in the mail. And so you want to be able to respond efficiently because, as I mentioned earlier, there are important time deadlines that are triggered from the service of a union election petition. You want to think about what are prospective bargaining units and organize, the required information. So depending on the nature of your workforce, you want to think about what would be a good unit, a bargaining unit. Is it in a grocery store, just, the deli department or one department? Or can you facilitate the entire grocery, store having similar trends and similar, community of interest so that they should be the same bargaining unit? Depending on the nature of your workforce, it may be more advantageous for you to have a larger bargaining unit if you can use more employees to dilute union support. The unions like to organize sort of smaller micro units in a way to get into an employer's work site, either by department or otherwise, and because you don't need as much union support in order to achieve and win that election. And that might be one way of them getting in. So if you're able to think through your workforce and anticipate what would be an appropriate bargaining unit, that can be very helpful in any legal arguments responding to a union election campaign. You want to develop and train management on effective communication plans. Mark and I have done a lot of this training even before there's any hint of organizing, before you hear any of the buzzwords or even concern that there might be an interest of union organizing. It's really important to train your team so that they know what they can and cannot say to employees if they do have questions about organizing tactics. There are a lot of legal rules and do's and don'ts, and once you arm your management team on what they can say, it gives them a level of comfort and it empowers them to be able to know that they can respond and say something appropriate without being caught flat-footed. And that training, I think, is really important even before you hear of organizing. And then the last thing I want to talk about before I turn this over to Mark are neutrality agreements. Unions have used neutrality agreements for years as a way to avoid union campaigns. If I can get a company to agree to say, yes, I will be neutral in this campaign. I will not, voice any opposition to the union, and I will let you essentially, take cards of my employees, and if a majority of the employees sign cards saying that they want a union, then I will recognize the union without an election. That's called a neutrality agreement, card check agreement. It's been our advice and counsel that employers never sign one of those because it takes away the rights of the other employees to say whether they want or not want to be represented by a union. But recently, last fall, we got a case that involved a hotel in Seattle where the general counsel of the board issued a letter stating that the hotel who entered into this neutrality agreement violated the act by providing more than ministerial aid. The union, the Unite HRE union in Seattle is livid. I was in contract negotiations right when this decision came out, and one of the union had a proposal on the table to have neutrality agreements for future hotels that this company might open in the city. And I mentioned this letter and this issue from the general counsel, and he just got so red in the face and so angry about this decision. But I think it's a really important point that you want to have in getting leverage and rejecting any proposed neutrality agreements. At least right now under the current board, they're going to consider agreeing to a neutrality agreement is an unfair labor practice, and that would give you a lot of arm to shut those agreements down. So with that, I'll turn it over to Mark to talk about some recent cases in front of the board.
Very good, thanks, Kara. And yeah, Kara and I have worked together for some time during our careers, and it's interesting to see the pendulum start swinging back once again. As Kara mentioned at the outset, during the 8 years of the Obama administration, the National Labor Relations Board was quite active in overturning long-standing precedent, and some of the cases that I'll discuss will show the ongoing restoration of prior precedent that was overturned by the Obama board. One study, I think back just shortly after President Trump was elected, had calculated all the years of precedent that were overturned during the Obama administration, and it claimed something like 4,500 years of precedent in all the various cases had been overturned by the Obama board. So there's been an ongoing restoration of prior precedent under the Trump board. I'll talk more about the most recent cases in that ongoing restoration, but there are plenty of cases that have already swung back into a more prior precedent friendly, a more reasonable and balanced approach is how I think most employers would see it to these labor related issues. These include, most of you are probably familiar with the Caesars Entertainment case that came out I think last year, which reestablished the right of an employer to restrict an employee use of its email system. It overruled Purple Communications, which was an Obama era decision. And now, once again, as it had for the decades that email had been around, employers can control its email and IT systems so long as there's no discrimination against unions. That's how it always was. Other cases like MV Transportation dealt with contract coverage standard. We had the board has engaged in rulemaking regarding election rules, and it restored the prior standard for handbooks under which the Obama Labor Board had reached out to many even non-union employers were caught up in unfair labor practice charges before the Obama Labor Board. Well, I won't belabor all that. I said I would talk mostly about the most recent cases, so I do want to touch on a couple of those that may be of interest to some of you. This first one, where the board again reestablished many decades of precedent that it had no jurisdiction over religious institutions. This is the Bethany College opinion, which just came out this summer. As you can see, I noted that it overruled Pacific Lutheran, which was an Obama era decision from 2014. The jurisdictional test that the National Labor Relations Board is relying on was adopted by the DC Circuit in 2002, and it relies on a Supreme Court case from 1979. So you can see how far back this goes. But basically, the current board declined to exercise jurisdiction over a religious institution, this Bethany College, and they've set forth this Great Falls test as this test going forward. The board must decline to exercise jurisdiction over the faculty at an institution that, and I list the 3 requirements there, holds itself out to students as providing a religious educational environment, is a nonprofit, and is affiliated with, owned, or controlled by a recognized religious organization. That's generally pretty easy for a religious organization to meet. So you'll see the board will not be exercising jurisdiction over religious institutions going forward. Let's talk a little bit this is pre-contract, and I'll talk a little bit about post-contract on the next slide. But again, I'll start with the Obama era decision, which came from 2016 when that board issued total security management. As you can see, it overturned 80 years of precedent. The entire time that the act was in effect, it had been construed that, or it had never been construed that an employer had to bargain with a union that organized its employees. There was no obligation to bargain prior to actually signing a collective bargaining agreement with that union. No obligation to bargain over employee discipline. And the total security management decision overturned all that precedent and stood until just this summer when the new NLRB in this Care 1 at New Milford case restored the prior precedent and held that once again employers have no statutory obligation to bargain before imposing discretionary discipline that's materially consistent with that employer's established policy or practice. So that's kind of an important case, especially for the newly organized employers, because you maintain control consistent with what you already had, you as the employer already had prior to the organization and before the agreement to specific terms in a collective bargaining agreement. This can be a big deal for a newly organized employer, and again shows the more reasonable and balanced approach that the Trump Labor Board takes to these issues. Let's talk about the duty to bargain post-contract. Many of you probably know, if you're dealing with labor unions, when you have a collective bargaining agreement that expires, you have a duty to maintain the status quo when the collective bargaining agreement expires. And the status quo includes, paying the same wages, keeping the same rate, paying the same, maintaining the insurance benefits and paying that same rate. Still continuing to contribute to the pension or a 401k, things like that. You just maintain the status quo. Most terms, however, expire with the CBA, including I'd like to mention the arbitration provision. So you have no obligation to arbitrate after expiration of the CBA. You do probably have an obligation to process a grievance, but not all the way through arbitration, because arbitration is a matter of contract. But let's talk about this Nexstar Broadcasting case, which came out earlier this year. And this was not necessarily, or not even, a pro-employer decision, so much as consistent with the idea that the employer, if the employer is going to make changes after the expiration of the collective bargaining agreement, it needs to have the language survive the expiration of the contract, the language which gives it the right to unilaterally change the status quo. So in this case, the board actually ruled against the employer, but reinforced the notion that the contract expires, and if you're going to exercise a right to change something under that contract, you need to have some language to allow that right to survive the expiration. This is consistent, I mentioned earlier some of the cases that the Trump board has issued. This was consistent with the decision in MV Transportation, which came out last year. It was an issue of first impression as to whether the contract coverage that was a standard that was adopted under MV Transportation applied to changes made after the collective bargaining agreement expires, and the board held that it does, and even where it gets an employer, they still ruled that way, so it was all consistent. So just the thing to draw from that opinion is that if you'd like to act unilaterally after the expiration of a contract, try to include some language in your CBA that that right will survive the expiration of the contract. All right, let's go on to the contract bar. This is kind of a big deal, and it hasn't happened yet, but I thought I would mention it, that this is something that shows sort of the more pro-employer bent on the current labor board. The contract bar, many of you are probably familiar with. It says that employees cannot vote. The board will not process a decertification petition against the union during the term of the contract, of the collective bargaining agreement, but only for up to 3 years. So if you have a contract that goes for a term of longer than 3 years, only the first 3 years would be protected by the contract bar doctrine. And in that case, a petition to decertify a union would be rejected by the labor board on the basis that the contract bar prevents it during the first 3 years of any collective bargaining agreement. So in effect, when a union agrees to a collective bargaining agreement with the employer, the employees no longer have a right to vote to decertify the union. Well, in this case, this Mountaire Farms Incorporated, this was out of the 5th region too, which is out there by DC, where Carey is. The employee had collected a petition from his fellow employees at this Mountaire Farms, and he got the more than 30%, which is the standard that you need to petition for an election. He got more than 30% of his fellow employees to sign this petition, presented it to the board, and the union, which was the UFCW, United Food and Commercial Workers, responded that the election was barred by the contract bar because the petition was filed in the 2nd year of the 5 year. They had a 5-year contract, and this was filed in year 2. The director of the 5th region held that a compulsory dues clause in the contract was facially unlawful because it lacked a mandatory 30-day grace period. So they were taking dues before they were allowed to do so, which also prompted the employee at issue here to file some unfair labor practice charges against the union himself for taking dues illegally and then for threatening him after he submitted this petition. But the board, the regional director, scheduled a mail ballot election, and the union sought to delay it a couple times, and also filed a request for review. Well, I think it was, let's see, in July, maybe around the end of June, I think, the board granted the request for review, and the employee, who was now represented by the National Right to Work Foundation, had urged the board to, that if it did grant review, then to take on the notion of this contract bar, because as I note there on the slide, the contract bar that says you can't process a decert petition and for the 3 years is not based on any statutory language. The statute doesn't say anything like that. The closest it comes is it has a 1-year election bar, which says that you can only hold 1 valid election per year. But there's nothing that says that a contract prevents a vote in the statutory language. It's just board-created law. And the employee in this case said, well, if you're going to take up this case, you ought to reconsider the entire contract bar and do away with it. The fact that there's a collective bargaining agreement shouldn't impinge on my right as an employee to organize my fellow employees if we're dissatisfied with the union and want to have a vote. So interestingly enough, the board did grant the request for review and said that it is going to reconsider or consider the contract bar and whether to retain it or modify it or what to do with it. So it issued a notice and invitation to file the briefs. It then extended that deadline, I think from August something. Now the briefs are due to the board, and this is any interested parties can file a brief to provide advice and input to the board on this issue. And I'm sure that lots of interested parties are planning on doing so. Those briefs are now due a week from today on September 23rd. And it will be interesting to see what the Trump Labor Board does with this opportunity to eliminate an extra statutory standard that has just cropped up and been in place for many years, but is not based on anything that Congress enacted. And in fact, Congress chose not to have a contract bar when it implemented the National Labor Relations Act. So my instinct is that the board will probably strike down and or at least modify the contract bar to no longer be in place for 3 years. And it'll be interesting to watch that case. And I urge you, any of you that are interested to pay attention to that in the coming months as the board ponders that decision. Again, it just shows the more employer friendly folks that are in charge at the labor board now. Let's go on from there and talk about another recent case that came out at the end of July. This is the General Motors case. I say modified the standard. It really more restored the standard for determining whether employees have been lawfully disciplined or discharged after they make abusive or offensive statements. And just as sort of a rundown of some cases from the Obama era as to what we're talking about, it's really, profane or sexually unacceptable remarks, even racist remarks. In Plaza Auto Center from 2014, an employee cursed the owner of the business up and down, F, MF this, and effing crook, and called him other words that I won't use, to his face, told him nobody liked him, threatened that he'd regret firing him, right to the owner's face. And the Obama board reinstated that employee. In Pier 60 in 2015, the next year, also under the Obama board, in a Facebook post, an employee was protected when he called a certain manager a nasty MFer and F his mother and his entire effing family, what a loser, and things like that. And that was protected activity. Finally, in Cooper Tire and Rubber Company in 2016, the Obama board held that the employer violated the act for discharging a white employee after when he was picketing on behalf of the union. He shouted to black replacement workers, "Hey, did you bring enough KFC for everyone? And hey, anybody smell that? I smell fried chicken and watermelon," and racist remarks like that, and was discharged, and the Obama board reinstated him. So that was sort of the standard that was implemented during those years, and this General Motors sort of puts paid to a lot of that, and took a lot of the tests for different standards in different places. Like they had a test for outbursts related to management that were in the workplace. They had a separate test for picket line conduct. They had another separate test for postings on social media. And the board has just sort of combined them all and said, we're just going to follow the familiar right line test, which is a case I think dates back to like 1980 and has been the standard that's been used for basically all unfair labor practice charges for 40 years now. Under that case, the general counsel, the board, must first prove that the employee's protected activity was a motivating factor in the discipline. And if that burden is met, the employer then has a chance to prove that it would have taken the same action even in the absence of protected activity. And this standard now that will be followed for this profane outbursts that the board has now sort of consolidated under this General Motors standard will make things, I think, much more a rational and reasonable approach, and more in line with other statutory standards that employers have to follow under Title VII, and to not allow harassing or racist speech, which these sorts of outbursts, conflicted, and you even had, reinstatement of employees for things that wouldn't be tolerated. I found a quote from Chairman Ring on the board that he released with this case, and he said this, and I think it's right. This is a long overdue change in the NLRB's approach to profanity-laced tirades and other abusive conduct in the workplace. For too long, the board has protected employees who engage in obscene, racist, and sexually harassing speech not tolerated in almost any workplace today. Our decision in General Motors ends this unwarranted protection, eliminates the conflict between the NLRA and anti-discrimination laws, and acknowledges that the expectations for employee conduct in the workplace have changed. So I think that that's a welcome change, should be a welcome change for everybody, except for profane, abusive, or racist employees. And that's just too bad. So that's another recent case that I think we all can applaud. Let's go on to beyond case law. The board has acted in a few instances, and Kara mentioned like the election rules. It proposed a separate amendment here to its representation case procedures. So towards the end of July, it issued a notice of proposed rulemaking that did two things, and I'll talk about the first thing on this slide and the next one on the next slide. But the first was dealing with so-called Excelsior list, and any of you who have been through a union campaign are probably familiar with an Excelsior list, which draws its name from a case way back when that was called Excelsior underwear, I think, something like that. But anyway, it's just called an Excelsior list. And for many decades, whoops, sorry, I accidentally hit my space bar and muted myself. Sorry about that. Under this Excelsior underwear case, employers had to file an eligibility list of eligible voters that had the names and home addresses, and do so within 7 calendar days after a decision in direction of election. That was in place for forever and ever, from like 1960 something when the Excelsior case came out. Well, in 2014, when the Obama board proposed its election changes, one of the changes was to expand the amount of personal information provided, and not just, now it's not given just to the regional director, it's now given directly to the union. And you had to give the union, the Excelsior list had to include all, quote, available personal email addresses and the home and personal cell phone numbers directly to the union, and to do it within 2 days of the decision and direction of election. Not only, but this word available was subject to interpretation, and it was often construed to mean, you know, if individual employee had given his or her individual manager her cell phone number, for example, but nobody else had it in HR or throughout the organization, that could still be determined to be, after the fact, be determined to be, quote, available, and the failure to provide it could have been a unfair labor practice impacting the election, and the election results could be overturned based on something like that. So now the board has proposed that employers will no longer have to provide available email addresses and home and cell numbers of eligible voters, relying on the privacy interests of the employees involved. And we'll look more at a balance between the privacy interests and the purposes that underlie the voter list requirement. So that's kind of interesting that they're looking to roll that back. Comments are due on it now, and expect this board to act with dispatch once it has all the comments and consider everything. Right now, it's looking to implement a rule that would allow 5 days, 5 business days, and would obligate employers to provide the full names, the work location, the shift, the job classification, and the home address, but not personal email or personal cell phones. That's kind of important. Let's go on to the other proposed amendment to representation case procedures. This one's a little more minor, but again shows the more balanced approach there, or even more proactive pro-employer approach that the board is taking. It's looked at the idea of military people, employees on military leave voting, and since at least 1950, the board has taken the position that mail balloting for employees that were on military leave is an impracticable measure. Well, in this recent notice of proposed rulemaking, the board relied on USERRA, which is a Uniformed Service Employees Act, and this UOCAVA, which was trying to remember, I think it's like Uniformed and Overseas Citizens. I think it's Citizens Absentee Voting Act. And they said, well, this demonstrates a policy that these folks should be allowed to vote. And we think that the change in technology and the facts on the ground here in the ensuing decades means that we probably could provide absentee mail ballots to military members. So let's get some comments on how to do that. And they set a comment deadline for the different logistical issues that may come up in doing something like that. So it'll be interesting to see what they do there in trying to allow members of our armed services to participate in union elections. All right, let's go to the next slide. I know we're getting near the end here, so we'll probably close with this. I wanted to touch briefly on some COVID-19 related issues. I know Kara did too, on some of the organizing impact of COVID-19. First, let's talk about doing mail ballots in union elections. That deals with this Aspiris Kiwina case that I put at the top there, which just came out at the end of August. In July or thereabouts, maybe in early July, the General Counsel issued a GC memo and said, here's some protocols to follow in implementing elections, and we think that manual ballots should be the norm, and it generally has been through the decades under the National Labor Relations Act, and set some protocols that employers could use to make sure that elections were back in the workplace rather than conducted through mail. And that's kind of important for employers because this manual balloting has long been the preferred manual at the method at the board. And mail balloting is generally held under less controlled conditions and is more prone to irregularities, let's say. And mail ballot elections don't have as much participation, which employers generally want higher participation. So this is kind of an important decision because even after the issuance of that GC memo in July, a lot of regional directors were exercising their discretion to continue to set elections for whether or not to choose a union. They've been setting them for mail ballot elections in almost all the cases. Well, the board upheld most of those decisions, or all those decisions, until it issued this Aspiris Kiwina, and it granted the employer's emergency motion to stay the regional director's decision that this would be a mail ballot election. And it looks like it's going to probe those the underlying discretion used by the regional director there, and maybe / hopefully get a more pushback on whether the election should be held manually or through mail ballot. That shows the board's preference, again, is for manual elections, and we'll see what they do in that case. The XPO cartage case was issued just a few days before that, and I thought that I would mention that. There was another case, too, at William Beaumont Hospital just before that XPO cartage case, in which the board granted decisions to file special appeals of the administrative law judge's orders that said that supplemental hearings before the board would be conducted by video conference. And then it denied the appeal in both of those cases. So it shows that it could have video conference hearings before the administrative law judge, which has been ongoing. And then shortly after that, the general counsel released another memorandum that instructed the regional offices to hold remote hearings for almost all unfair labor practice matters and hearings. So this is also another COVID issue that's impacting the board and showing that they're going to generally have a video conference rather than a hearing, unless two requirements apply. The region believes that unusual aspects of the contemplated trial would make a video hearing unfeasible, or there's witnesses that the general counsel wishes to call who do not have access to equipment that would enable a connection to the video technology platform the agency uses for its remote hearings. The board did note in this XPO cartage case that the video conference wouldn't deny the employer due process, and that you could raise non-speculative concerns during the video hearing and still file an appeal from that without prejudice. That seems to me probably the most reasonable result, and that's what the GC memo, which was issued right at the same time as this XPO cartage case, that's the result that it came to. So that's it for the COVID-19 issues I thought worthy to touch on, in addition to what Kara addressed in labor organizing. And I think that's it. I think that's it for the slides. Am I right about that, Kara?
Yeah, I think that's right. Please check out our employer defense report blog. We update it regularly with COVID and non-COVID and labor-related, employment-related issues. So please register for that if you're not already a subscriber. And then we do have a couple more webinars for the rest of the year. Next month, we'll be talking about conducting background checks under federal, state, and local law. In November, we'll be covering federal wage and hour issues. And then finally, talking about the impact of America's aging workforce.